Hi everybody, welcome to this first video for chapter 3. In this video, we are going to talk about some just kind of basic laws that govern the fraud and forensic accounting that we're talking about in this class. So I would like to preface this conversation by stating that I am not an attorney. That is not my area of expertise. I am an accountant. So that is the area in which I am an expert. So the law is not my area of expertise. So I just want to make sure that it's clear. Everyone knows that I am not an attorney and I'm not holding myself out to be one. So again, we're talking about a lot of different laws. So I thought this little cartoon was kind of funny and fitting. So just as kind of an introduction, so fraud can be prosecuted either criminally or civilly. So what does that mean? So criminally means someone is arrested, someone is going to trial, someone is facing maybe jail time or has to do community service. That's a criminal case. So civilly means that one person feels that they have been harmed and that they don't think the criminal case was enough punishment, if you will, or they're not satisfied with the outcome. So they can then take them to court or sue them civilly. In this case, they'd probably end up seeking some sort of damages or remedy from the person that they feel wronged them. And we can have both a criminal and a civil case. So both of those could happen either simultaneously or one right after the other. So fear of getting caught. So one of the best ways to prevent crime is with this fear of getting caught. It's actually the fear of getting caught is a bigger deterrent than actually the fear of punishment. People just don't want to get caught doing a crime. So getting caught doesn't just mean getting caught by the police. It could also mean getting caught at school or maybe through some other organization, just a member of the community who's watching out, having that watchful eye on the community that could also catch that wrongdoer. So just having this idea that I could get caught doing something wrong is usually enough to deter people. The fear of punishment, I don't want to get in trouble for doing wrong. It's not only that I don't want to get caught, but I just don't want to get in trouble. Both of those fears can help to deter people from doing bad stuff. Another thing is most people are law-abiding citizens. People want to play by the rules and they believe that the legal system is there for a reason. We may not agree with everything. We might not think it's perfect, but generally the system works and our society is better off if everyone just plays by the rules. So most people are just going to do what they're supposed to do. The criminal justice funnel is just kind of, if you think about a funnel, at the top it's really wide and then at the bottom it narrows out. This is thinking about the number of crimes that are committed compared to the number that are actually tried and convicted. So if you think about the top of the tunnel, we have a whole bunch of crimes that might have been committed. Maybe these never even get caught. Or someone might catch them, but they don't get reported. There's a lot of those at the very top of the tunnel where it's wide, but very few actually make it out to the bottom of the tunnel, the funnel, which is really narrow, which represents the small number of crimes that actually make it through the criminal justice system. So that's what's meant by that criminal justice funnel. If we think about regulatory agencies, so other than just the criminal and civil justice system, other agencies can also play a role in monitoring illegal activities. So for example, we have the SEC, the IRS, PCAOB. These are just a few other regulatory agencies. So the SEC is responsible for bringing civil and administrative actions against anyone who breaks the law related to, the stock market or stockbrokers or things relating to securities and exchange. The IRS, they're responsible for collecting taxes and enforcing the tax laws. The Internal Revenue Code So that's their goal. And then the PCAOB was created by the Sarbanes-Oxley Act in 2002 after a whole host of frauds took place. So basically they were formed to oversee the auditing firms of public companies. So entities that trade their stocks have to have an audit performed by or in accordance with the PCAOB. So again, these are other regulatory agencies that could help, with that fear of getting caught, that could catch people. So one thing we're going to talk about in this chapter is the rights of individuals. So most fundamental individual rights are grounded in 4 amendments of the U.S. Constitution, and they're associated with due process. So first we have the 4th Amendment, which is the right or the prohibits unreasonable search and seizure. The 5th Amendment is you plead the Sith, as my little cartoon said in the beginning, provides the person they can't give testimony against themselves. So, when you stand up in a court of law and you put your hand on the Bible and you swear to tell the truth, the whole truth, and nothing but the truth, you don't have to tell the truth about yourself. So you have that right to not testify against yourself. The 6th Amendment is the right to an attorney, or you can also defend yourself. You also have the right to confront witnesses that are bringing testimony against you. And then the 14th Amendment is you have the right to due process and also equal protection under the law. So as employees, individuals have an obligation to cooperate with their employer, or else they could be subject to dismissal, no longer having a job. Other rights can also be established through maybe an employment contract, or if you're in a union, a collective bargaining agreement. But there are fewer rights to employees than we would think of as regular individual rights. There's also the whistleblower laws, which protect employees who report improper or illegal acts, either to their employer or to the government. And these laws basically protect the employee that blows the whistle from retaliatory or punitive actions. So I'm going to speak on each of these things in the coming slides, but basically the rights of the individuals in relation to interviews and searches and surveillance and discharge, and also other privileges that we have. So I'm going to talk about those next. So if anyone has ever watched Law and Order, you've heard someone getting arrested and heard them being read their Miranda rights. So the Miranda rights has the following statements. So you have the right to remain silent. You have the right, anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. So these are the rights that have to be read to someone as they are being arrested. With regard to the 6th Amendment, as long as a non-public entity is conducting the interview, so if we're talking about, interviewing employees, the employee does not have the right to have a lawyer present. So if you're being interviewed by a forensic accountant who's not law enforcement, the employee does not have the right to have a lawyer present, nor does the employee have the right to consult with their attorney prior to an interview. So that is not a right to private employees. The employee still has the right to consult an attorney if they request one. So if they're in an interview and they say, and it sounds pretty bad, they can stop the interview and request an attorney. Private employers do not have to offer employees due process. These are things that are more governing law enforcement. What else? Common laws. In addition to having various common law. People have other protections under the law. So it's particularly employees. So if we have the minimization of invasion of an employee's privacy, limitations on the interview content, limitations on public disclosure of the employee's private facts, limitations on intentional infliction of emotional distress, limitations on defamation. So these are some things that employers cannot do. No false imprisonment. We're supposed to act fairly and in good faith. So these are some things that employers are supposed to have in that relationship. Finally, confessions resulting from interviews and interrogations. They can be kind of challenging. In order for a confession to be valid, it has to be deemed voluntary. So confessions can't be obtained through coercion or threats of violence. Also, promises by the interviewer of leniency can nullify or revoke that confession. However, promises to recommend a lighter sentence or to report cooperation, those are not necessarily considered coercive in nature. So we have to be careful when we get a confession that we're not using coercion or threats in order to get that confession. Searches. The Fourth Amendment protects individuals' rights against unreasonable search and seizure. So first, unreasonable search and seizures are forbidden. All warrants for searches and arrests must be supported by probable cause, and all warrants must be reasonably specified as to the person, place, and thing that they are after. A major exception to this is if law enforcement has reason to believe that a crime has been committed or is about to be committed, and an immediate search is required to either stop or prevent that crime, then the Fourth Amendment allows that search to happen. When we're talking about workplace search and seizure, what about that? So a search warrant is not required to conduct a workplace search for investigation of workplace misconduct. The issue is that workplace investigations are substantially different than those conducted by law enforcement because the goal is not law enforcement, but rather efficient office operations. So privacy is not expected in your workplace. So you might expect to have privacy in your house or in your car, but in your workplace, we don't have that same expectation. The one little area where we do is if we have exclusive control. So exclusive control is like your desk. No one else is going to get into your desk. So you might assume that you would have some sort of privacy in your desk. But maybe like a cabinet where everybody puts their files, that wouldn't necessarily give you that same right of privacy. So for a workplace search to be considered reasonable, it has to meet two conditions. So first, the search has to be justified at the beginning because of some sort of evidence of workplace misconduct. So we have to have a justifiable reason that we're carrying out the search. The second criteria is that the search is necessary to further the investigation. So we're not just searching because we think you're doing something wrong, but we think that we might be able to get some evidence through the search that would be useful in the investigation. So with regard to search limitations, when we are doing a workplace search, the scope of the search must be limited to what is necessary to serve the organization's legitimate work-related purpose. So we can't just go and look at everything. We have to limit what we're looking at to what is serving our work-related purpose. There may be no limitations at all if the employee has no reasonable expectation of privacy. So again, if we have that exclusive control, we may have a little expectation of privacy. However, if we've met the other two criteria, even if we have that exclusive control, a reasonable expectation of privacy, we still could, if we've met those other criteria, we still could search their desk where they do have that exclusive control. The last thing is fruit from the forbidden tree. So if we gather any evidence from an illegal search and seizure, all that evidence is not going to be admissible. And that's what we call the fruit from the forbidden tree. So we might get some really great evidence that shows that a person did really bad stuff, but because that evidence was gathered illegally or not using the proper channels, we can't use that against the person. Surveillance can be more complex than interviews and searches. If you're intending to use surveillance, you should probably consult an attorney before you get started, because some may be allowable and some may not. So these can include electronic surveillance, audio and video monitoring. Fixed point surveillance is like a stakeout where you're sitting in your car watching what happens. Mobile surveillance. Videography is just videoing without sound. When you add audio into that videography or just audio surveillance, that is where things can get a little tricky. So audio recordings have a whole host of requirements for when they're allowed, but generally video surveillance is permissible as long as it does not violate a person's reasonable expectation of privacy. So if you're in a public park or a parking lot, and someone is videotaping you without your knowledge, that's typically okay because you're not someplace where you would expect privacy. If you're in a home, in an employee restroom or an employee locker room or changing area, that is areas where video surveillance wouldn't be allowed, because we would expect privacy in those areas. So let's assume an employer suspects an employee of a fraud act. Can that employer just fire that employee? What if the person won't cooperate in an investigation and the investigation can't continue because they're not cooperating? Can we fire them then? Generally, an employment is considered at will, which means either the employer or the employee can end that relationship at any time for almost any reason. But if an employee feels that they have been dismissed for improper reasons, they could have some protection under the law, even in an at-will state. So because of that, it is important to always document a good cause for termination. So, you were conduct against a written policy. You're supposed to be at work at 8, you show up at 8:15, 3 days in a row. That could be a good cause for dismissal. Conduct made for unsafe or inefficient operations. So we say that you have to wear your safety goggles when you're working and you're never wearing them. The punishment has to fit the crime. So we have to make sure that we're not kind of abusing our power. And then evidence supports questionable act by the employee. So we have some evidence to support that. So we want to make sure we are documenting the reason for dismissal, so that we have reason for dismissal. So nothing prevents the employee from suing the employer in civil court. So it may not be a criminal case. They may have been allowed to dismiss you, but they could still sue you because they feel like they've been wronged. The next thing I want to chat about is privileges. So there are some legal privileges that are not protected under the Constitution. So these include the attorney-client privilege, attorney work product privilege, physician-patient privilege, marital privileges, and then miscellaneous privileges. So let's chat about these. So the attorney-client privilege. So the attorney-client privilege is the right to not disclose any confidential communication relating to the professional relationship. So if you come into my office and if I'm an attorney and you come into my office and we start talking about your case and you tell me that you did it, or you admit your wrongdoing, I would not be required to disclose that information. The privilege belongs to the client, and the client has the right to compel non-disclosure by the attorney. So the client can say, you can't say this, or the client can say, you can say this. So it's the client who really decides what can and cannot be shared. So the attorney has to just kind of zip their lip, but if they are allowed to disclose something, that is at the client's request. This applies only to communication intended to be confidential. So if we're in an attorney's office having a confidential conversation, that is protected. If we're at a dinner surrounded at a table where everybody can hear it, then that's not confidential, and those conversations would not be permitted. It does not permit the attorney to conceal physical evidence. So even if we have physical evidence and documents, we would have to include those. So that is not included in the privilege. It also does not apply to future acts of crime or fraud. So if we say, I did this in the past and I'm going to do it in the future, it doesn't apply to future acts. We have to communicate those, or the attorney would have to communicate those. Attorney work product privilege. So work product is any material that you prepare in anticipation for litigation. So we put together all of our, in auditing, we call them work papers, all of our things. The attorney would not have to disclose what we have put together. Any written material that has been prepared for a case is included in work product, but it must be prepared in anticipation of litigation. So if we're not anticipating litigation, then we wouldn't have to prepare, this privilege would not exist. Physician-patient privilege. So we can communicate with our doctors or our psychiatrists or psychologists when we are obtaining treatment or diagnosis. So the physician would not be able to disclose what was discussed in those meetings or in those medical conditions. This doesn't relate to court-appointed physicians. So if I'm meeting with a doctor that the court has appointed or an expert witness, those privileges do not apply. It's just if you're working with your own personal doctor in the treatment of specific illnesses. Marital privileges, so spousal immunity. So this protects a person from having to testify against their own spouse. So I wouldn't have to testify against my husband wouldn't have to testify against me, but I could if I wanted to. The spousal defendant protects the other spouse. So some states allow this and some states don't, but the spousal defendant allows where it protects the defendant from the adverse testimony of their spouse. So if their spouse decides to testify against them, it would prevent that from happening. It also covers statements made during and after, or during the marriage, but if they subsequently divorce and they're no longer married, it still holds. Last, some miscellaneous privileges, confidential communication with clergy. So if you go to confession and confess your crimes, that would be confidential. Government has privileges that protect the disclosure of sensitive information. So the CIA or the FBI, they have things that are considered secret and would not have to be disclosed. Also, trade secrets for businesses, you know, the special recipe for KFC's chicken doesn't have to be disclosed. Finally, no privileges for accountant-client relationship. So if we have a discussion with our client, we don't have privileges there. We don't have attorney-client privilege or expectation of privacy. So just remember that there's no privileges for accountants. Last thing I want to talk about is the Daubert standard. So this is the test currently used in the federal courts and some state courts related to the admissibility of expert witnesses. So determining if an expert is truly an expert, if their testimony is considered expert. So under these standards, the judge would make an assessment of whether an expert specific scientific testimony is based on reasoning or methodology that is scientifically valid and can properly be applied to the facts at issue. So that is what is used when they are deciding whether or not to allow expert testimony. That wraps up the first video. I've got one more for you, so stay tuned.